Hello everyone, welcome to yet another session of the Daily News Analysis by SRIRAM'S IAS, where we take up the important articles featuring in the Hindu newspaper and break them down for our understanding from the UPSC examination point of view. So let's start our today's discussion by taking the important articles which feature in the newspaper, which are on our screens, and let's take up the first article for the day. The first article which appears in the newspaper reads, Chandrachud nominated as the next Chief Justice of India. Now, this was a significant development that happened yesterday, where the incumbent Chief Justice of India, U. Lalit, has nominated his successor in the form of the 50th D.Y. Chandrachud, who's set to become the 50th Chief Justice of India. So, in this backdrop, what becomes important for us to know from the examination point of view is that how exactly is the Chief Justice of India appointed to the Supreme Court, and what is the procedure that is followed and other provisions involved in this aspect. So let's understand these provisions. The judge who's set to become the next Chief Justice is known as D.Y. Chandrachud. In the legal circles, he's quite a celebrated judge, having given landmark verdicts such as the right to privacy judgment, the K.S. Puttasamy judgment, the decriminalizing 377 in the Navtej Johar judgment, and also recently permitting abortion beyond 24 weeks and also recognizing marital rape in a judgment. So these have been some of the landmark judgments which Justice D.Y. Chandrachud has been a part of, and now he's set to become the next CJI. But what becomes important is that how exactly is the appointment of Chief Justice done? So when we talk about the appointment of Supreme Court judges, it flows from the principle of keeping the judiciary independent as well as powerful enough to perform the functions as one of the pillars of the democracy. So therefore, it is very important to keep the judiciary independent, and this independence would be first ensured by the appointment procedure of the judges. If the appointment is not, one can say, influenced by the executive or other arms of the democracy, that is when we can say that the judiciary is independent. So independence as a principle must be incorporated in the appointment of Chief Justice. So what does the Constitution say in this? The CJI and the judges of the Supreme Court are appointed by the President under Clause 2 of the Article 124 of the Constitution. So Constitution under its Article 124 gives us the procedure as to how the judges of the Supreme Court and also the Chief Justice of India would be appointed. So it is mentioned in Article 124 that appointment by the President, which means that the nodal authority which will give his stamp to appoint the CJI for the Supreme Court would be the President. So the CJI is appointed under the seal of President, and that appointment is to be done after consultation with the judges of the Supreme Court, as the President may deem necessary. This line over here, which is a part of Article 124, later went on to become a very significant line in the judicial history of India. How so? We'll take a look in a short while, wherein this particular phrase after consultation became the genesis for the origin of the collegiate system in India. How did that happen? We'll take a look in a while. So Article 124 mentions the procedure that President would be appointing the Chief Justice of India, and that would be done after consultation with the judges of the Supreme Court. So judges of the Supreme Court should be consulted, and this consultation, the meaning of this word consultation is what came into contention in the Supreme Court, wherein question arose that when we say that the President, while appointing the Chief Justice, is to consult the Supreme Court judges, does this mean that this consultation is voluntary or mandatory? This was the question that was taken, and while answering this question, the collegiate system evolved. So how did it evolve? The collegiate system first was taken up in the first judge's case in 1981. As I said, the question of answering the phrase consultation as to is it a voluntary process or is it a mandatory one? In the first judge's case in 1981, the Supreme Court said that this consultation was a voluntary one, and therefore established, one can say, a primacy of the executive over the judiciary, and it was therefore assumed that the opinion of the Supreme Court judges in this manner is a voluntary one to take and not a compulsory one to take. Therefore, it declared that the primacy of the CJI's recommendation on judicial appointments and transfers can be refused for cogent reasons. This would mean that the executive can refuse the judge's opinion. And this ruling gave the executive primacy over the judiciary in judicial appointments for the next 12 years. This was the first case that happened in this tussle between executive and judiciary. Then came the second judge's case. The second judge's case, in this case, the Supreme Court found out that this was a mistake that had happened wherein the executive had gotten more power. And as we discussed, in order to have a well-functioning judiciary in a democracy, it is very necessary that we maintain the independence of judiciary. And that is why in the second judge's case, which took place in 1993, 12 years after the first judge's case, in this case, Supreme Court introduced the collegium system, holding that consultation phrase, which we saw in Article 124, really meant concurrence, which means that unless and until the Supreme Court judges are also of the view, and their view is should be given more importance to the executive's view, and this would be the decision of the collegium system. Collegium system is nothing but a group of judges coming together from the Supreme Court and deciding on the appointments. So this collegium system was introduced in the second judge's case, and it added that it was not the CJI's individual opinion, but an institutional opinion formed in consultation with two senior most judges in the Supreme Court. So this meant that the collegium system would have 3 members, the CJI heading it, and 2 other senior most judges of the Supreme Court will be a part of it. Currently, the collegium system has a set of 5 judges, where the strength of 3 from this time has been increased to 5. Then in the third judge's case, Supreme Court on the precedent's reference expanded the collegium to a 5-member body. This was done in the third judge's case. So this was the development of the collegium system, which acquired primacy and became a big pillar. Later on, the government also tried to do away with the collegium system by incorporating the National Judicial Appointment Commission Act, or the NJAC Act. But this act was held as unconstitutional by the Supreme Court, and now still the collegium system continues. But we are establishing the importance of collegium system to understand the appointment of the CJI. So let's come back to the appointment of CJI. So as we saw, this appointment of CJI has to be done on the recommendation of the collegium. And so what happened yesterday? Yesterday, incumbent CJI UU Lalit gave the name of the next successor. This name was asked by the Union Law Minister. This is mentioned in the government's memorandum of procedure for the appointment of Supreme Court judges, where seniority is to be given the norm, right? It says the Union Minister of Law, Justice and Company Affairs seeks the recommendation of the outgoing Chief Justice of India for the appointment of the next CJI. So which means that upon the date of retirement nearing for the current CJI, the Union Law Minister asks for the recommendation of the next CJI's name. And here is where, after consultation of the collegium, the incumbent CJI will give the name of the next Chief Justice of India, and this would be then submitted to the Law Minister, who will then put up the recommendation to the Prime Minister. The Law Minister will take that recommendation to the Prime Minister, who in turn will advise the President on the matter of appointment. And when when we say advise the President, this advice is binding on the President, which is given by the Council of Ministers, and thus this is how the President appoints the Chief Justice of India. So this is the whole process, and what is the things that are surrounding the procedure of appointment of the Chief Justice of India. Now, after appointment, what are some of the other provisions, such as who is qualified to be the Chief Justice of India? So let's look at how they're appointed and the qualification. So as we saw the appointment procedure, apart from the CJI, the other judges are also appointed by the President after consultation with the CJI and other judges of the Supreme Court and High Court as he deems necessary, right? And we have established how the phrase consultation has come out to be interpreted as obligatory in this manner. Now, when we talk about qualification for being a judge, or in this case, the Chief Justice of India, he should be a citizen of India. He should have been a judge of an High Court or High Courts in succession for 5 years. So it's a mandatory provision that he should have been a judge in the High Court for 5 years. Or apart from that, he can either be an advocate of an High Court for 10 years. So the provision is that he should be a citizen of India. He should either be a judge of the High Court for 5 years or an advocate practicing in the High Court for 10 years, or can be a distinguished jurist in the opinion of the President, which means that even if he's not an advocate or judge fulfilling this requirements, if the president feels that this person is of a distinguished jurist nature and he has the required knowledge, he also can be elevated as a judge. And the constitution has not prescribed minimum age for appointment as a judge of the Supreme Court. So there is no minimum age bar on the appointment of judges of a Supreme Court. So these are the qualification of the Supreme Court judges. Now when we talk about the tenure of the Chief Justice of India, what would be the tenure? So the constitution in this manner specifies the tenure where there is no fixed tenure of the judge. However, it makes the following three provisions in this regard is that the constitution provides an upper limit on the age gap. So the CJI can hold office until he or she attains the age of 65 years. And any question regarding the age is to be determined by such authority and in such manner as provided by the parliament. So the parliament will decide the question of the age in this manner, and the age that is specified is 65 years. And in between his tenure, the CJI can anytime resign his office by writing to the president and can only be removed from his office by the president on the recommendation of the parliament. So the removal procedure of the CJI is a very critical point for us to understand, where he is removed as per the removal procedure similar to the president. So similar to how a president is removed is very similar as to how a Chief Justice is removed and other judge of the Supreme Court as well. So a judge of the Supreme Court can be removed from an office by an order of the president. But this order, he can issue this removal order only after an address by parliament, which means that the parliament has to pass a motion which is called as a impeachment motion of the judge, right? And has been presented in the same session for such removal. This motion has to be passed by the special majority. When we say special majority, it means that it should be passed by the 2/3 member of the parliament present and voting in the house. So when 2/3 member of the parliament pass this particular motion, then is when one can say that the impeachment motion has been passed, and then it is forwarded to the president, and the president would then remove the judge. But has there been any removal of a judge in this process? It has not been. No judge up until now has been removed through the process of impeachment. There have been motions that have been initiated, but none of those motions have been passed up until now. And what can be the grounds of removal of a judge? So two grounds are there. Either you prove a proven misbehavior on their part, or incapacity of holding the office. These are the two grounds of removal which are there for the removal of CJI. And which particular parliamentary act takes care of it? So the Judges Enquiry Act of 1968 regulates the procedure relating to the removal of a judge of the Supreme Court by the process of impeachment, right? So these were the important provisions that were surrounding the office of CJI, where we saw how the Chief Justice of India is appointed, what is the collegium system that plays a role in it, and what are the qualifications and other provisions related to the Chief Justice and other judges. So when we talk about the powers and functions of the CJI, the main power which distinguishes him from the other judges is that he is also called the master of the roster, which means that he is the one to decide which judge will be presiding under which cases. So he decides the bench who will be comprising of what kind of bench in which case. So this was a discussion on this article, and with this, let's move on to our next article for the day. The next article which appears in the newspaper reads 3 lakh and counting RTI pleas pile up at information commissions across India. Now this is an article which gives us a significant data point wherein a particular NGO has tried to take one can say a summary of how many RTI applications are pending in the information commissions across the country, and they have come up with useful data which we can make use of whenever a question is asked in this particular aspect in the mains examination. And we know that RTI is a very constant topic, and almost every year a question is asked on the Right to Information Act. So what is this Right to Information Act? Before we understand what this report says, the Right to Information Act actually is a very landmark event in our Indian democratic history, because when we talk about the citizens interacting with the government can very well behave as a very opaque system where what functioning is going on in the government, the citizens might never come to know about it. This is where a movement started wherein the citizens also themselves became aware that they wanted to exercise their right of wanting to know the procedures and processes followed by the government and the reasoning behind all the decisions taken by them. This is what led to the right to information movement. This was supported by the Supreme Court, where the Supreme Court also sowed the seeds of the RTI Act, wherein it held that the people of this country have a right to know every public act, everything that is done in a public way by their public functionaries. Since the government that is working, it is working for the people. That is why the citizens get a right to have every information about the government's decision making and functioning system. But is this possible? The government and if we take a look at the relationship between government and citizens, it's a very lopsided relationship with respect to power. The government has much more power than the citizens. Therefore, there was an instrument needed which could empower the citizens, and this instrument came in the form of the RTI Act, which was enacted by the Parliament in 2005. This act encompasses the right to know, wherein it says that the citizens have a right to know about the government system, and it directly flows from the concept of freedom of speech, which is mentioned in the Article 19 of the Constitution. So therefore, this particular RTI Act, or the Right to Information Act, actually guarantees the fundamental right of citizens. Therefore, this RTI Act was passed, and again, why do we need a strong RTI? The ideal of government by the people makes it necessary that people have access to information. We saw this, and the free flow of information about affairs of the government paves way for debate in public policy and fosters accountability in government. And it also creates a condition for open governance, which is foundation of democracy, right? So this establishes the need for RTI. But let's come back to reality for a bit. After enacting the act, and when we look at the performance, where nearly 17 years will be completed of the RTI Act, how has the RTI Act performed? Is it really happening that whenever the citizens want to know something, they can file an RTI application and they would come to know about the decision-making process or other aspects of the governance system? This is where we are looking at the reality of the performance of the RTI Act, that it has not been up to the mark. And this is where we need to highlight what issues are being going on with this RTI apparatus. This is where the report comes in, which is highlighted certain issues that are going on. What are these issues? The report that features in the article says that nearly 3.15 lakh complaints and appeals are pending with 26 information commissions across India. So this RTI Act has a system of establishing information commissions at the state level as well as at the national level. These are some of the key provisions of the Act, where the Section 4 of the RTI Act requires suo motu disclosure of information by each public authority, and there is a contentious section which is known as Section 8. This is a very infamous section because under this section, the authorities have the power to exempt any information, wherein if there is any information which pertains to certain sensitive matters of governance, in that aspect, the government might even refuse to give out such an information. And that power is mentioned under Section 8 subclause 1. And 8 subclause 2 provides for disclosure of information exempted under Official Secrets Act 1923 if larger public interest is served. Basically, Section 8 subclause 2 says that if there is any information which would violate the Official Secrets Act of India, which pertains to sensitive information and secrets, in that aspect, the authorities might refuse to give out such certain information. So, in this provisions, as we saw, there are national and state commissions. So, this is where the report says that across all these commissions, there are 3.15 lakh complaints pending, which gives us an idea as to how smooth the process of responding to pleas and appeals is going on. The report says that 2 information commissions of Jharkhand and Tripura of the 29 across the country have been completely defunct for 29 months and 15 months respectively. So this report highlights the dismal state of 2 information commissions, that is of Jharkhand and Tripura, wherein the information commissions have not been functioning at all for as long as 29 months and 15 months. Not just this, Manipur, Telangana, West Bengal and Andhra Pradesh commissions, these 4 commissions are without chiefs at the moment. The chiefs of these commissions are known as the Chief Information Commissioner. They exist at the state commission level and the national commission level. These 4 information commissions do not have the Chief Information Commissioner at all. Then only 5% of all positions in these commissions are being occupied by women. So the women occupancy in these commissions is also very low. And the other important issue with respect to the RTI is of the denial of information, which we saw, the usage of section 8. Yes, there is a power in the act which makes the authorities enabled to refuse information, but a lot of times it is seen, which is observed by the Supreme Court as well, that this power is not being used in a just and fair manner. It's said that the public information officers have evaded the general public from getting the rightful information that they are entitled to, which means that this power has been wrongly used in a lot of instances. So these are some of the issues that plague the RTI apparatus in India, and only when we plug these issues, wherein the all the procedures that are involved, which information has to be divulged, it has to be made clear, then the enforcement of these these things also have to be done. And another change which the government has done with respect to the RTI is about the amending of the RTI Act. So recently, the government initiated an amendment in the RTI Act wherein it tried to change the apparatus of the Chief Information Commissioner and the Information Commission's provisions. So earlier, where the Chief Information Commissioner and Information Commissioners will have a tenure of 5 years, this new amendment will may change the tenure of the commissioners, and it made sure that this tenure would be decided by the center itself. So earlier, where the Chief Information Commissions had the fixed tenure, in the new amendment, center can change their tenure at their will at any point in time. So does this create an impact on the independence of the Chief Information Commissioner? We can guess that it will have a great impact. Then the quantum of salary has been also altered, where earlier the Chief Information Commission was paid according to and similar to what the Chief Election Commissioners were paid, other vigilance commissioners were paid. But in the new amendment, the salaries and allowances of these officers will be again determined by the central government. So this also again creates a dent on the independence of the functioning of these information commissioners. Then there have also been deductions in salary in the new amendment. So these 3 are the major changes that the government has made in the amendment to the RTI Act. And this is also, when this amendment came last year, there was a lot of furore over these amendments, because a cursory glance in these amending these provisions can be seen as harming the independence of the information commissioners. So these are some of the issues that plague the RTI apparatus, which we took a look at, and this is where we finish our discussion on this article. And with this, let's move on to our next article for the day. The next article which appears in the newspaper reads, Non-Traditional Livelihoods, Skilling of Girls Included in the Beti Padhao Scheme. Now this particular article appears in the newspaper, where the scheme Beti Bachao and Beti Padhao is coming into focus, and the earlier mandate of the scheme is being expanded and other aspects are added to it. So in this aspect, we'll understand what is the Beti Bachao and Beti Padhao scheme and what are the additional mandates that are being expanded under this scheme. So this scheme, Beti Bachao, Beti Padhao, as the name suggests, talks about saving the girl child and educating the girl child, which are 2 of the most important intervention areas required when we talk of the safety of the females in India. So it was a scheme launched in January 2015 with the aim to address sex-selective abortion and the declining child sex ratio, which was at 918 girls for every 1,000 boys in 2011. So as we can see, this scheme was launched to basically take care of 2 activities, where the sex-selective abortion were being done and to take care of the declining child sex ratio. It became a joint initiative of the Ministry of Women and Child Development, Ministry of Health and Family Welfare, and Ministry of Human Resource Development. These 3 ministries come together to implement this scheme, right? And this program is being implemented across 405 districts in the country. A recent announcement was also came with respect to this scheme, which was expanded to other districts of India as well. So what are some of the main objectives of this scheme? First is prevention of gender-biased sex-selective elimination, which we saw. Second is ensuring survival and protection of the girl child. Third is ensuring education and participation of the girl child in the education system. And fourth is protecting rights of the girl children. So in pursuant to this, the scheme is launched, and under this scheme, there are various activities that the government does, such as making sure that the girls have proper health, increasing the gross enrollment ratio of girls in schools, making sure that the health of the girls is proper, and providing them with nutritious meals in schools. All of these are activities which are carried out under this scheme. So what is now being added under this scheme? So the expansion of mandate is being done in the Beti Bachao Beti Padhao scheme, where inclusion of skilling of girls in non-traditional livelihood options is being done. Now, what do we mean by non-traditional livelihoods? So for girls, when we talk about non-traditional livelihoods, it means that those are those avenues of earning money or livelihoods which are traditionally not seeing participation from women. So one such field is taken as the STEM field. In today's day and age, STEM field is nothing but a field which has science, technology, engineering and mathematics as a presence in them. These STEM fields see very less participation of women. So therefore, these schemes will now focus on increasing the enrollment of girls in the secondary education in these STEM fields. This is the increase of the mandate of the scheme, wherein it wants to skill girls in the non-traditional livelihoods, those livelihoods which generally girls do not participate in. So this is about the expansion of the scheme. But what are some of the issues that plague the Beti Bachao and Beti Padhao scheme? So recently, a parliamentary committee gave its report. A parliamentary committee on empowerment of women submitted a report in parliament and flagged certain concerns with respect to this scheme. What were some of the concerns? The first issue that the report highlighted was that the poor utilization of funds were happening, which means that for the amount of funds that were allocated to the ministries for the implementation of the scheme, since the inception in 2014-15 till 1920, the total budgetary allocation under the scheme was rupees 848 crore, excluding the COVID package. And during this period, an amount of rupees 622 crore was released to the states, but only 25% of these funds had been spent by the states on this particular scheme. So it highlighted that the adequate spending of funds was not being done. And the second important issue that it highlighted was, even in this spending, it highlighted improper spending, which said that a whopping 80% of the funds under the scheme was spent on media campaigns and advertising purposes, and not much money was spent on actually implementing the scheme by taking root level activities and making or increasing infrastructure in the villages. So it highlighted these two issues about the scheme, which we should also take a look at. So this was a discussion today on the important articles from the newspaper, and we'll meet again tomorrow with the important articles. Thank you.